But there isn't law you cannot. You can't convict me.
Because he's saying that the judge doesn't know law. A judge who holds your life. And let me tell you, the offense upon which Nnamdi Kanu is charged is a capital offense. I hope you know.
Capital offense.
Capital offense is not a terrorism. I understand. They are not 1 year, 2 years imprisonment. They are, if you are found guilty, they are sentenced to life imprisonment or death, something like that.
Wow.
Yeah, so I don't know. But nevertheless, I know that the Kanu will not be killed now because what he stands for. I know that the political solution will eventually come. Happen. It will surely come. We are entering the election year. And I know that Tinubu may want to sacrifice Nnamdi Kanu
by letting him
go so that he's not sacrifice him, but we may want to free him so that he can win election and get South, because clearly the North is not supporting Tinubu. And if the North is not supporting Tinubu and the Southeast feel that Tinubu's government convicted Nnamdi Kanu, then it means that for Tinubu to win, it's only the South and the Yorubas and they support him.
Which will not be enough.
Which will not be enough. So he may want to let the Igbos have a sense of belonging by freeing Nnamdi Kanu. So political solution still remains the only option for Nnamdi Kanu to, and it can still happen. It can still happen.
Okay, please make sure you share this video, comment and let us know what your take on this. Don't forget that we are not in support, and now are we against whatever judgments the court decides.
Analysts.
What we are just trying to do is just to analyze and give you facts and figures of what is actually playing on ground based on the law and based on the Nigeria constitution. Share this video. Make sure you share this video. Comment utterance that he made while actually in court that you don't know the law. Let's start. Barrister, please, can you really interpret and tell us about what he meant by you don't know the law?
What?
That's what he said. That the judge doesn't know the law or the lawyers, because he actually fired his lawyers, and now he seems he knows the law more than the lawyers. And
well, that's what he said. Now he was accusing the judge of not knowing the law. But the truth is that you cannot tell a judge not knowing the law. This is a criminal trial. The criminal trial is one upon which you say your own. The prosecution will say or you say your own. Then the judge will rule. It's not yet time for the judge to rule now. So if the judge is not yet time for him to rule, how can you be accusing him of not knowing the law?
The judge have actually fixed 20th November as possibly a time to possibly get a ruling regarding to this.
Well, yes, the court gave the Nnamdi Kanu several opportunities. I think 6 opportunities to defend himself. But all the time Nnamdi Kanu will come. And we've got to give him, I think, 6 days or so to defend himself. But every time Nnamdi Kanu will come and say that at first he said that he was going to call 34 witnesses, government personnel. Then later, the next day, his lawyers withdrew. The court ordered him to go and prepare his defense. The next day, he now said he was not going to he was not going to call 34 witnesses again. And he's going to defend himself. The court adjourned the matter again. The next day, he now came to the court and started talking about repeal law. That he wants to move him or repeal law. The court told him that this is not the right procedure. That he should go and get an expert in criminal law that will help him to do the thing. The court adjourned the matter again. Then later he kept talking about repeal law, citing cases and repeal law and all these things. But the truth remains that this is not the right time for you to move that motion. Some of these things are what you would have done during your final address. How it is done is that the procedure is that if the prosecution gives the evidence, the next thing for you is to give your own evidence. First of all, at that point that the prosecution gives the evidence, what you should do is to raise a no-case submission, which is lawyers rightly did. They raised the no-case submission, and the court overruled the no-case submission. At that point, the only duty you have is to give your evidence. After giving your evidence, you testify as to your defense. Then the prosecution will ask you questions. After that, if there is anything you have to say about the charges, you now raise them in your final address. That's the law. You raise them in your final address. Let me explain this thing for people who are not lawyers to understand. When the case is starting, when the charge is being read to you, that is the point upon which you raise an objection to the competence of the charge. Once you have taken plea on the competence of the charge, you are not expected to raise objection to the competence of the charge because you have submitted to the jurisdiction of the court. That is the law. I hope you understand what I'm saying.
Yes.
At that time, because we call it arraignment. At that time, you have to be arraigned. That is when your lawyer should file something and say, my lord, this charge is incompetent based on repeal law. This charge is incompetent based on duplicity, or based on being ambiguous, or based on not disclosing a reasonable cause. These are the grounds upon which you can
But
you can raise objection.
the lawyers did not do all these processes or what?
No, no, no. What is there that from what we know now, from what we know, those charges, they look at the law self, the law again. Nnamdi Kanu lawyer actually made some objections to the law, to the charge, upon which the court overruled him. And the law is that if the court overrules you, then you must commence your trial. Your trial must commence. You will not, the trial will not be suspended because you raise objection. That's the law as the Administration of Criminal Justice Act, which is the act upon which Nnamdi Kanu is being tried. Under that act, if you raise objection as to the competence of the charge, the law is that the court will rule on it. If the court agrees with you, the charge will be struck out or the charge will be dismissed. Especially the charge will not be dismissed but struck out, because dismissal means maybe dismissal acquittal, but the court will struck out the charge, or the prosecutor may decide to amend it. Then at that point, if it's amended, you continue the trial. I hope I'm making sense to you. But if it is not, if the objection is overruled, then you are to commence your trial. And it happened in Nnamdi Kanu's case. His lawyers went on appeal to the Supreme Court. Remember when the appeal was going on, Nnamdi Kanu was starting trial. As his appeal was going on, the Court of Appeal agreed that the charges, the Court of Appeal now struck out some charges. If you remember, the first application was before Justice Bin Tanyako, upon which I think 7 or 8 charges were struck out, if you remember.
Yes.
Then the second application was appealed at the Court of Appeal, upon which the Court of Appeal held that the ordinary edition is applicable. The court agreed and the second acquitted him. Then they went to Supreme Court. Supreme Court said no, that he should go back to stand his trial. So that procedure has been followed.
But Nnamdi Kanu have always make reference to Supreme Court.
The Supreme Court ordered. I'm not. Wait, so I don't have interest in this matter. Before somebody will say that I am talking as based on what I know as a lawyer.
Okay, you're just analyzing.
Yes, the Supreme Court ordered that he should go back and stand his trial. The Supreme Court ruled that extraordinary rendition is not a part of our law. Now the law, our law.
Okay, it's not part of our law.
Yes.
That's the reason why Nnamdi Kanu have always said they don't know the law. They don't know the law.
That's what I'm saying.
Because if they know the law, they won't be. Nnamdi Kanu won't be facing trial on what the law does not. The law does not.
No.
Is that the area is coming?
Nnamdi Kanu saying they don't know the law. I don't know what he means by that. But let me tell you something.
Okay.
The Constitution of Nigeria provides that before a particular international convention can be a law in Nigeria, that what you will do is that the National Assembly must pass that international convention to become a law. I don't know whether that makes sense to you.
Yes.
Assuming Nigeria goes to Rome and signs international convention on the protection of human rights, that's law. That international convention is not binding in Nigeria until you take that international convention and take it to the National Assembly. The National Assembly will now pass it as a law upon which the president will sign. That is it. So you don't bring an international convention and you don't have signed and use it and argue in Nigeria. Just like the African Charter of Human and People's Rights. It was codified and brought into domesticated inter-Nigerian law, what we call Chapter 10. So it is now, when you talk about Chapter 10 or Captain, every lawyer knows that you're talking about African Charter of Human and People's Rights. So what I'm saying is that what the Supreme Court said was that international rendition upon which Nnamdi Kanu's lawyers have been happy on, that decision, that extraordinary rendition has not been domesticated under Nigerian law and is not applicable. The Supreme Court now said that based on that, Nnamdi Kanu should go back and stand his trial. But the only way I thought the Court of Appeal was that the federal government should have released Nnamdi Kanu at that point that he was acquitted by the appeal court. But nevertheless, they did not do that. But that's an interlocutory order. They now filed the interlocutory application. So what I'm just saying is that the argument of Nnamdi Kanu, where he's now raising preliminary issues of law, cannot be raised at this point. The reason is that the time to raise those preliminary objections is during arraignment.
Okay, let's look at one of the comments from a lawyer who happens to operate a page that's called a People Parliament. He said, what kind of judgment are you expecting Justice James to give on this? He said the The judge will make judgment from what the prosecution present before the court. Since there is no defense against it, we should not forget that you cannot sue a judge for any judgment they make, even if they make a wrong judgment. He went further to say they have what we call judicial immunity. Please take note. I'm not saying the judge will make a wrong judgment. I'm only trying to educate us about it. If Nnamdi Kanu is not pleased with the judgment on November 20th, the only option available for him is to go to appeal court.
He's correct now.
To go appeal the judgment.
The prosecution proved their case, and Nnamdi Kanu's lawyers were told to enter a no case submission. They were defend. They said they want to go a no case submission. The court overruled them and ordered Nnamdi Kanu to defend the matter. Now that Nnamdi Kanu has refused to defend the matter, the court has only one issue: to analyze the judgment. You know, during the no case submission, during the ruling on the no case, you don't analyze the judgment. You only make 2 or 3 lines that, based on what you have seen here, that there are prima facie evidence upon which the court should discharge. I mean, the prima facie evidence upon which the accused person should be called to enter his defense. That is what the law says. In no case submission, the judgment is not long. It's just 2 or 3 lines. But if the court accepts the no case submission, then the judgment is holistic. That is the law. So now that the court rejected a no case submission, the court will now give its own reason to convict Nnamdi Kanu. So there is nothing you can expect except a guilty verdict.
So likely on 20th, Nnamdi Kanu will likely be.
That's the law now. He will be found guilty now. There is nothing else to extend because he did not defend his case. That's the law now.
So if
he did not defend his case,
possibly they will have had a longer time.
Yes, if he had, maybe the young man is in a hurry to leave DSS custody and go to Kuje prison. But the DSS can also apply that he continue staying with them.
Are you serious?
It's possible now. The DSS can apply that he continues staying there. It's a dangerous situation, honestly. But if Nnamdi Kanu had allowed his lawyers to defend him, the lawyers would have defended him. Then those issues of repeal law he's talking about, the lawyers will use it as a defense to say that there's no law upon which he's being charged. But let me say this, as a lawyer, people should understand how the law works. If there is Terrorist Prevention and Prohibition Act of 2017, and later there is a Terrorist Prevention and Prohibition Act of 2022, which replaced the former law. To me, it doesn't really mean that anybody who committed a crime on that law, that that person should go home because the law is no longer there. No. If it's a criminal offense, at the time that the crime was committed, there was a law. And moreover, it is not, the question is, can you really say that that law has been repealed when there is no express word prohibiting its repeal? Or even if there was express word, there's another law replacing it. So sometimes some of these things you call repealing is an amendment.
So like what they're saying in conclusion, based on the fact, and including what the people Parliament is like, right, also say that based on the fact that Nnamdi Kanu, there was no defense on his case.
Everybody knows James Omotosho cannot rule. James Omotosho cannot rule now that Nnamdi Kanu is not guilty because he has only ruled that Nnamdi Kanu has some questions to answer and that have shown me that he committed offense, that he should not go into his defense. He has only ruled on that now. I'm telling you, I'm not here to please you. I'm talking as I've been a lawyer for 26 years, or 25 years, and what I'm saying
just speaking based on
law.
Based on the law.
The judge has already ruled that Nnamdi Kanu has a question to answer or has a defense to give.
Is this not the best time for the political figures to come and offer a political solution as people have?
I don't know. It's not I'm a lawyer, not a politician. You're asking me based on what I know as the law is. Yes. I'm not here to talk about what politics is. It's the politicians that were there. But let me be honest to you. Talking about politics, the way I see it, the way things are played out in recent times, it's not going to be easy because I know how government works. Government looks at remorse. You may be charged for an offense, and if you have shown remorse, the government may somewhat set you free. But for what I'm seeing there, I don't know whether the remorse is there. I'm not saying it's not there. But from what I know, somebody, yes, based on what I'm seeing, you know what I'm seeing.
I don't know what they're saying.
But nevertheless, miracles can still happen.
Let's-
The political solution can still happen. Nnamdi
Yes,
Kanu.
yes,
Miracle
yes.
can still happen. But if I were Nnamdi Kanu, what I would have done is to do what we call stupid to conquer. That's what lawyers do. My lord, you don't respect my lord. You talk to the court with dignity and respect. Therefore, you win your case. But when you go to the court assuming Mr. Know All, the court will show you that you want to humiliate me. Okay, I will show you. It's a normal thing in life. Because he's saying that the judge doesn't know law. A judge who holds your life. And let me tell you, the offense upon which Nnamdi Kanu is charged is a capital offense. I hope you know.
Capital offense.
Capital offense is not a terrorism. I understand. They are not 1 year, 2 years imprisonment. They are, if you are found guilty, they are sentenced to life imprisonment or death, something like that.
Wow.
Yeah, so I don't know. But nevertheless, I know that the Kanu will not be killed now because what he stands for. I know that the political solution will eventually come.
Happen.
It will surely come. We are entering the election year. And I know that Tinubu may want to sacrifice Nnamdi Kanu
By letting
him go so that he's not sacrifice him, but we may want to free him so that he can win election and get South, because clearly the North is not supporting Tinubu. And if the North is not supporting Tinubu and the Southeast feel that Tinubu's government convicted Nnamdi Kanu, then it means that for Tinubu to win, it's only the South and the Yorubas and they support him.
Which will not be enough.
Which will not be enough. So he may want to let the Igbos have a sense of belonging by freeing Nnamdi Kanu. So political solution still remains the only option for Nnamdi Kanu to, and it can still happen. It can still happen.
Okay, please make sure you share this video, comment and let us know what your take on this. Don't forget that we are not in support, and now are we against whatever judgments the court decide.
Analysts.
What we are just trying to do is just to analyze and give you facts and figures of what is actually playing on ground based on the law and based on the Nigeria constitution. Share this video, make sure you share this video.